as a business, you do not want to be on the FCC's radar. So make the steps to make sure that you're in compliance with this because the fines are hefty. The problem for real estate professionals is your information is everywhere.
Welcome to Signature Buzz, your go-to podcast for real estate professionals looking to elevate their game. In this episode, we're going to talk about the new FCC regulations under the Telephone Consumer Protection Act, the TCPA, that was supposed to go into effect on January 27, 2025. I believe real estate professionals still need to understand how these changes would impact their outreach efforts. Joining Chris and I today is David B. Sanders with Lex Technica Law firm to break down what you need to know. Dave, no stranger to the real estate industry, are you?
No. Hi, guys. It's glad to be here. So we're kind of in a bit of a scramble because as of last Friday, the rule was set to go into effect on the 27th until the 11th Circuit Court of Appeals issued kind of a ruling that basically says that it's not going to be, they vacated the rule. Most of us are expert industry advisors and followers are kind of surprised that the court made this decision at this point. Most of us were kind of thinking that the one-to-one consent rule was going to go into effect. So it's not going into effect. And we'll go ahead and talk about the background of the rule, what the ruling means to you as a real estate professional, and then steps to go forward. So the TCPA was passed in 1981, and it requires prior express consent for non-emergency calls to cell phones, including text. That means auto dialers and pre-recorded voice messages as well. So in 2012, the FCC defined prior written consent for marketing calls, including a written agreement with the recipient's actual signature for calls to residential lines. And then in 2023, the FCC under the Biden administration changed that rule to be what's called a one-to-one consent, meaning that the rule required specific consent from one seller tied directly to one telemarketing communication company. So the FCC at the time was controlled by the Republicans or by the Democrats, and so they had most of the Republicans on the panel voted against this. So that's important because as we move forward into the new administration and who appointed the judges in question, you're going to see that the Republicans kind of push back on this. So the idea was intended to close some sort of a lead generation loophole where consumers gave blanket consent to everybody. So what the 11th Circuit ruled was, hold on, FCC, you've gone too far. The FCC, the 11th Circuit was a 3-panel judges, all appointed by the President Trump, and they said the TCPA's plain language says prior express consent, not prior express consent plus all these other requirements and conditions. So the court said, hey, consumers only have to give clearly and unmistakable indicated their willingness to receive robocalls. It doesn't have to be a one-to-one. And that opposing one-to-one goes beyond the TCPA scope and the FCC scope. The court argued essentially that there's going to be no way that they feel that this one-to-one rule is going to be valid under the way that the TCPA is written. So it was really a big pushback on the FCC. So that means that the rule that was supposed to go into effect on the 27th isn't. And you can go ahead and continue to do your business with the prior express written consent standards. Now, that being said, there are several types of platforms and carriers that still require this type of a rule. They, as a business, they can require a higher standard than the federal government. So you should be looking at your agreements. So if you are a business person who does this type of thing, we've got some suggestions for you later on after we talk about what we think is going to happen next with the FCC and this rule. So the 11th Circuit remanded, that means sent it back to the district court to look at and determine further proceedings. But considering the ruling, there's really little wiggle room for reinstatement of this rule. The rules on text blocking and extending the national do not call registry to text messages do not change. So if you do a lot of block texting, still keep in mind that those rules, text messages now are covered by the do not call list. So what do we think happen going forward with the FCC? Well, the FCC now.
Wait a minute. We'll ask the questions.
Yeah.
So excited.
I got to know something, though. Like 1991, when we had phone issues, I mean, my mom's cell phone in 1991 was in a box in the back of the car. So, like, this has been around a long time where they've had regulations on how you could call people. Like, I know it was 8 a.m. to 9 p.m. based on the consumer's time zone, things like that. But, like, how does this happen? Is like Harvey Specter at the 11th district and he's, fighting for us to make these calls? I mean,
you pulled in a Suits reference. That's good.
Believe it or not, it wasn't. It was the combination of credit unions and people who make phone calls, including real estate professionals. So Harvey was not there. But I'll be honest with you.
how about Louis Lit?
I've never seen Suits. I don't know. So, but it was a combination of businesses that make these types of phone calls. And part of the problem is this rule was created in 1991. And technology has dramatically changed. I mean, everybody who's got a smartphone now realizes that we're getting a lot more. Everyone's being more and more inundated with robocalls and scam calls, so much so that half the phone calls to my cell phone say scam on them. So I think what happened is that there was a lot of consumer pushback to people, bad players in the industry who were making these types of phone calls. And I think the FCC went too far. With their rule. Now, it's completely possible that they could make this change, but they would have to change the law, the TCPA. So Congress would have to go in and make that change. And I don't know about you guys, but with the way Congress has been set up the last few years, they have a hard time actually like funding the government. I don't think that the TCPA is going to be at the top of their list for the next little bit. So for people who do make robocalls as a part of your business, this is a good thing, because you can continue to make your business. Because frankly, if this rule would have gone into effect, we would be talking today about how the days of real estate agents being able to make those types of calls are dead and gone. So, this is a victory for businesses that do this type of thing. And, our partner with our law firm, Sam Castor, Sam went to school with the guy who is now the chairman of the FCC. And I think, Brandon, you were on the email where he said that, we don't think that this is going to, this FCC is going to continue with this line of concerns. If those of you who've been around in the real estate world, if you remember at the end of the Obama administration, we were talking about how the CFPB was coming for every real estate agent on the planet, and it was just going to be the end of the world. And then President Trump came in, the administration had a different shift. So I think that's kind of what you're seeing here as a shift from one administration to another with what their policy requirements are.
See, this is this rule. All of a sudden, there was a big uproar of agents with concern and stuff like that. Many of them, they never even made cold calls anyway, but they had this. And the big thing on this that I'm gathering and listening to you is this just affected really the auto dialers and the automatic text messages and stuff like this. This wasn't you making your one-on-one calls, correct?
Correct. When you enter into a real estate relationship with an individual client, you're not going to be covered by these rules. Specifically in like the listing agreement and in the buyer brokerage agreement, we put language in that document that authorizes you to communicate with your client by text and by cell phone. So I know that's kind of one of those things that most of you kind of just skip over, but that's just the language that we put in there to make sure that you can communicate. There are some timelines, like that authorization will expire typically 6 months to 1 year afterwards. So you need to if you have a forming list, you need to make sure that you're reaching out and still getting authorization to communicate with them. That's a very easy thing to do through your email blasts. The company that helps you should be able to put some language in your email that authorizes them to continue to communicate with you. So those kind of sentences, when you see those, that's what that means, is that you're getting permission to communicate. The issue really comes down to this was to me the big was people who call expireds, because that would be an argument where you don't have a one-to-one, because the consumer never gave the agent that's calling them because their listing was expired authorization to contact them. So I think that's kind of the biggest push. But
so I want to be clear though on what you just said, like, because it didn't go into effect. And if I'm not using an auto dialer technically, and I'm physically dialing the expired's phone number to inquire about their listing that they had on the market, can I still do that?
yes, you can. You can even still use an auto dial.
Now, if they say, don't call me anymore, and I've had people say that, and not very often because I'm fun to hang out with on the phone. But if they do, everyone keeps talking about the records. Like I feel like the Nixon administration here. How do you record these records? And what is the best practices for holding on to those that you recommend?
Well, if you're part of the Nixon administration, the first thing you don't do is break into Watergate. So after that, we can talk about real estate. So the key when they say marketing is just keep an Excel spreadsheet or some type of spreadsheet where someone says do not, they've indicated that do not call, so that you can remove them from your call list. You have that obligation. And you can get in trouble if you don't do that. That wasn't anything that those rules about when somebody says, do not call me, take me off your list. You still have to comply with that. That wasn't a change that was going to be impacted by this court's decision, but you still have to do that. So what I would recommend to the agents who do this is, even though this rule hasn't changed, it's probably a really good time to sit down with whomever you're getting your leads from and going through some questions. And I have a list of those whenever you want me to go over those. So
the question, like we've got agents that make calls, right? And they're going to have people to say, hey, put me on the do not call your list. What is the responsibility of the brokerage or the company, as agents are kind of independent contractors? Does that go up to every other independent contractor with the company?
Now, the only potential exposure there I see to other agents and brokers would be some sort of real estate division oversight, saying, if somebody's kept repeatedly telling an agent to take me off your do not call list, they didn't do it, and then they contact the broker didn't follow up, and then they call and file a division complaint. Then I could see that would be an issue, because that would be something that would be a lack of supervision. They're independent contractors, they're independent businesses. The way the FCC views this is, you wouldn't be responsible for the calls that I make, and I wouldn't be responsible for the calls you make. We're in separate businesses, and that applies to real estate agents. Now, teams are a little murkier depending on how the team agreement is set up. So if you have a team, you probably need to make sure that you're having a conversation about how we handle do not call this and how we handle call interaction to make sure that the entire team isn't running afoul of this issue.
So I always heard you say in this process, or what I heard in my mind was that I should document that I have a process and procedure that says what happened when someone says do not call, that mirrors what the FTC and the FCC say I have to have. And then I need to document that I told people, to mind their P's and Q's and do it the right way. And then after it happens and someone says, hey, even if I use a system that says I scrub the do not call list, which many do, and someone says, hey, put me on your do not call list, then I need to document that I have a process in place, that they're going to have that done. And I'll have all those things together. This phone prospecting is my business.
The easiest way to do that would be to automate it through your provider. Most of them have systems to do all of this stuff. I mean, when they talk about documenting back in the 90s, it was kind of when you had an Excel spreadsheet and you were literally just calling down people's numbers. You kind of then, your documentation would be, okay, this 702-867-5309, Jenny doesn't want me to call her anymore, so I'm going to strike that off my list. And you would literally just, cut it off your list. Now that it's an automated system, you'd want to see with your provider how they do that. And frankly, I would want to have that. That to me, that seems easier, just to have them upload it. Because if all of their, if they're providing you a list and they're saying it's vetted and it's confirmed, you're paying for that. So you want to look and see how they do that, and then what their track record is for actual compliance. I mean, if you've got a company that says they're going to give you leads, and then you look them up on the FCC, because you can look up these types of investigations and fines, and they're listed all over the place, you may not want to use them. So you need to do a little bit of due diligence with who you're selecting particularly right, because it's the beginning of the year. This is something you're going to do. It's a good idea to do this as an annual check anyway. This is just a heads up from the 11th Circuit that all the other rules still apply, and you still need to make sure that you're in compliance with that. So whatever vendor you're using, look at their agreement. That would be where I would start, and then go from there.
I just have one follow-up to that I technology change. You said it. So do not call. When I think of call, that's physically dialing on a phone. Is there a do not text and a do not email?
There is a do not text and a do not email. The do not text thing just came through. So you have to have text messages. You have to have specific communication. You'll see it if you're at like a Golden Knights game or an Aviators baseball game. You'll see, hey, text, 6565 to win a free, whatever. And then they'll very, very bottom say terms and conditions apply. And so when you text that, they're usually in a message back saying, hey, you texted us. This is to confirm you're opting in and you're going to be bound by all our rules and considerations. So you'd have to do that. Emails are the same way. You have to be careful with having a existing business relationship. So again, if you are getting these clients and communicating with them in your farm because you've worked with them or they've opted in to receive your messages, that's okay. I can always tell when I've gone and talked to an office and given out business cards, because all of a sudden I'm getting blasted by real estate agents who've just added me to their marketing, and I don't have the heart to, to file complaints. I just, disconnect. So you got to be careful. So emails, you got to be careful. Again, if you're using, because software has made this so much easier. If you're using like a company that blasts this out, they have all of that language at the bottom of the page. All those things in little small type that nobody else but lawyers and nerds read. That's where that's going to be. So check your email provider. Make sure that language is there. Like you're opting in to receive these emails. It's got to have the unsubscribe button for emails. That's all part of this kind of a rule. So the emails, they have to have the ability to say, unsubscribe. And text messages, you have to have an opt-in or stop, to stop receiving these in the future. And then the do not call list is the other way.
Well, I get a lot of text messages because I'm a member of NAR and they want to get me enrolled in health insurance and all that kind of stuff. And I didn't opt into them. Right. And I'm pretty sure about that. And then I've got but the iPhone has the ability, and I don't know, probably the Android too, to mark it as spam. Yes. Or junk, and it blocks that number. But they keep coming. But there's no opt-out feature on most of them. Is that non-compliant?
Yeah, it is non-compliant. I mean, there's some bad actors out there that will send you, I don't have a Netflix account. So when you text me and tell me that my Netflix account has been suspended, that's a scam because I don't have a Netflix account.
And why not?
Because he uses mine.
Yeah.
Not really.
Look cheap. That's what it is. And I thought streaming would save me more money than like regular cable, and it's exactly the opposite. So, there are some scams that are out there, and you can report those companies to the FCC, and the fines for violating the do not call list, violating this stuff, they're hefty. They're can be up between $1,000 and $10,000 per occurrence. So they're big, but the problem is that you have to actually file a complaint. So just using the block feature on your phone makes your life much more convenient, but it's not the same as filing a complaint with the FCC. That being said, look, if you get a lot of those, you do not want to be, as a professional, as a business, you do not want to be on the FCC's radar. So make the steps to make sure that you're in compliance with this, because the fines are hefty. And, no one likes those types of calls anyway. So, they're legal. Just bear in mind that you should probably be in compliance. So, yeah, you get a lot of those. Now, when you get random texts, there's also the possibility that your information's been leaked out on the dark web or the internet. So you should probably have, I have a service that helps me check that because I was getting a lot of those types of spams. So check that kind of thing for your own personal email if that's a concern that you have. Then you also got to be mindful of how you are giving your consent out. For example, hey, we'll give you 10% off our website if you agree to our text messages. Well, guess what? You just opted in to receive those. And depending on the language of their terms and conditions, you may have opted into every one of their affiliates. 10, 15, 20. So, looking at, how your trade organizations and how these companies use that data, and checking their terms and conditions, because it's possible that, I don't think NAR does this, but it is completely possible that someone could be selling your data. I don't think NAR does that, but you got to be mindful of when you're giving your information out for a discount that you're giving away your privacy for 5% off.
And so that's why you said, are you sure you didn't opt in? Because you may have, right?
May have.
Yeah.
But it also could be, the problem for real estate professionals is your information is everywhere, which you want. You want your information out there so that people can reach out and find you. The downside with that is your information is everywhere, and it makes it very easy to track that information down.
You're right. I mean, like when you get into real estate and you think of all the money that you spent marketing a telephone number, you can't just change your number because all those past clients and everyone have it. I had the same number, the same phone company for 25 years, not because they're the best, but because I didn't want to change anything, all the rules around it. I want to go back to one-on-one consent. And when I want to talk about past clients for just a second, because I don't ever remember as a broker anywhere in any form disclosure or anything, having a document that a client signs saying, this is your permission for one-on-one consent. Do I have to have a form? Can I just ask them and say that I ask everybody? I mean, what's the best practice for that?
The one-on-one, the consent for communication it's baked into your contracts. We did that when I was at LVR, when what I want to say one or both of you guys were on the board, if not when you were the president. So that's baked into the agreement. That whole, here's your contact information. You allow me to communicate with you. That's enough to get you there. It's also and part of the reason why we always tell agents to use the most recent version of the agreement is it's been updated in the last 3 or 4 years to include text messages. So if you're old school and want to use the contract from like 2003, you're going to have problems. So it's baked into that. It's an innocuous section that unless you know that's what it's for, it sounds like, oh, my real estate agent just wants to keep me in touch. Yes, I do, but I'm also going to be able to market you from here on out. And that's okay because you have a business relationship with them. When you didn't have, before the settlement of the NAR commission lawsuits, one of the concerns that I always had without having a buyer brokerage agreement was making sure that you had the actual consent to communicate with a potential client, because my guess is that most agents weren't sending a form over that they'd written inside their own office saying, you authorize me to communicate with you. That's baked into the BBA. That's baked into the listing agreement. So you should be fine once you have that relationship established.
I had no idea. That's awesome, Dave. I learned something I didn't know.
There's no time limit on that, or?
Genuinely speaking, it's usually about a year and a half. But again, if you get them signed up, they authorize you to communicate with them by email. You real estate agents are really good at sending out emails reminding me that today's National Chocolate Chip Cookie Day or whatever day it is today.
Really?
No, I just made that up. I wish. But you know what I mean? Like agents will send that out. They're making that close positive contacts. If you're using a professional service to send those, there's going to be language in the bottom saying by accessing this email, you continue to authorize us to communicate with you. And then the client has to do a specific opt-out. That's why it's very important if you're going to be going after past clients to continue, just from a legal point of view, to be reaching out and touching base with them on a regular basis so you can continue to keep them in your farm and your marketing systems.
So what I hear most often, and all leading up to this, like the biggest concern that I heard from anyone was people with automated dialing systems that had mobile lines of dialing where, they're just running off numbers as fast as they can to find one that answers so that they can call it back. And I think that the point I got from it is if you put the hard work in of making the dial, where you're actually putting your finger on the buttons, if phones have buttons anymore, and you're actually going through that process, you're okay in most cases, depending on the consent where that's at. But if you're using those robo dialers, that's a problem. Is that really what you think they're going to go after the most if they go further with this?
The key is going to be consent. So the key for this entire thing, which it's kind of ironic because it's very rare that oftentimes your legal responsibilities and what's best for your business kind of go hand in hand. But in this situation, it is like the whole purpose of calling those people is to get quality leads, right? So you will probably hire somebody to go through and vet those phone numbers so you're not wasting your time. If those companies are vetting those phone numbers, they're guaranteeing to you that you can communicate with them, that they're in compliance with the FCC. So it's gotten a lot easier because of technology. So agents, again, the key is pull your agreement with whomever you're getting this stuff with. Check to see that they're saying in writing in your contract that they will guarantee and indemnify and protect you should there be any issues with the FCC. Look these companies up on the FCC's website. The FCC, it's not 1-800-DROP-A-DIME or 1-800-RAT-OUT your realtor, but they do have a website where you can, or the members of the consumers, the public can go and anonymously file complaints. So you can look up these companies and see, do a little bit of due diligence before you sign the contract with these people, because a lot of these robo-dialer contracts are incredibly difficult to get out of after you've signed them. So you'll need to do your due diligence up front, vet them, review them. If you're putting significant money into this type of a process, it's probably worth it to have an attorney look at that agreement to see what your options are, particularly if the product is not what you had hoped. Some of these robo-dialer companies are incredibly aggressive, going after real estate agents who breach the contract because they say the leads are garbage and just stop paying. There's a possibility that these companies will come after you for collection. So be very mindful up front. If you're putting a significant amount of money, over $10,000 or $1,000, a significant amount of money, have an attorney look at this for an hour or two, review it so you know how to do it, particularly if you're going to sign a 1 to 2 to 3 year contract.
Okay, now I have a question, because when you talk about a robo-dialer, are you talking about something that dumps voicemails?
I'm sorry, I was not precise.
Because most of the agents that I know use what's called an auto dialer, and I wonder if there's a difference, right? Because an auto dialer, you're putting numbers in, so to speak, and you've got 1 or 2 or 3 lines dialing at the same time. Is there a difference, or are we kind of talking the same thing?
This is probably just me showing out how old I am, that I think of robots doing this rather than the internet. So it's any kind of automatic dialing system, right? Be it by, however system you do that. Where you're getting those phone numbers from is the key. I don't really care how you dial them. Yeah. It's where you're getting the numbers from. So however you're getting those, that's the question of vetting, permission, authorization, all of that stuff. So, the system to me is great. But these rules have been in place before the technology was there. You still have to have the authorization from the person that you're calling. And, most of the agents are not going out there and gathering these phone. Do people go through a phone book and just dial straight through?
No, you go to Cole's directory, right? And Cole's directory, to pull numbers, you've got to submit your do not call company registry number, so to speak. But they're not going to give you a guarantee that anyone's opted in. And I don't think most of these lead services that their real estate agents are buying them through, they're going to give them any guarantees either.
They should. They need to look at the agreement and see what it says, because if they're offering you some phone numbers, what they'll probably say is, hey, we vetted it, but we can't guarantee it. If you see anything, let it know. But you'll need to look and see, because the reality is you saying, hey, I bought these from, Jim's shady auto dialer, or whatever you want to call the company. That's not a defense to the FCC. They may go after them, but it's not a protection for you. If the FCC investigates you, what you want to be looking at is, hey, I did everything I could reasonably as a business to comply with the law. Here's my paperwork showing the way I got these people's information. And that's why I be buying them from this company. That's how I got it. Here's my records of, marking do not calls. And, here's the number that this person's complaining that was on the do not call list. Here's the record of them not being on here. Here's my record of me taking them off my list. What else do you want me to do? Where agents can get in trouble is they don't have any of that, because the way the FCC is going to look at you if you get investigated is they're already going to think you're the bad guy, and you almost have to prove your innocence. So you better have your paperwork in line in advance, because going back a year, 2 years later on who you called on January 27th, 2017, good luck.
I'll just tell them I don't prospect. They'll believe it. Hey, so I got a question that you just brought up, and it's one that goes back to phone books. I know this sounds funny, but I got a phone book actually at my house 6 months ago. I kept it so I could prove it. And I remember that, when you would get a home line and you would get it through the phone company, they would say, do you want your number published for $0 or do you want to pay to not have your number published so that it wasn't out there to the public? By not opting to pay to keep it unpublished, are these people giving permission for anyone that gets that phone book to call them?
Not for commercial purposes.
Okay.
So you could call them up and say, hi, my name's Dave. I need a friend. Do you want to come over and like
friend with a house?
It's tricky as I mean, you could use them for personal reasons, but commercial reasons, that's not typically enough because that's where the lead comes through. So, I mean, but it also, things have changed since the phone book was initially like that. I mean, you've got the do not call list, you've got things like that. But again, you could tell the phone company, don't publish my phone number, but then opt in to give all your information out for a free hot dog at a baseball game.
Makes sense. One of the big things, Dave, you hit on, and it's the automated messages. And I want to go to that for a second because, things like Slide Dial, those systems that are out there that, just put a voicemail into someone's voice message system. That was part of the 1991 Act originally, that automated messages that just went to your number. How has that evolved? I mean, like, I know right now, like agents ask me all the time, hey, I'm cold calling, should I leave a voicemail? And I don't know this person, they didn't actually answer the phone. What risks do I run?
Again, the key is if that person is opted into telephone communications from you, not a one-to-one, but generally opt in for those types of calls, you could probably leave a voicemail. Again, it comes down to where you're getting the lead. It's not necessarily, there might be business purposes that you don't want to leave a voicemail because people get angry. But legally, what we're looking at is, did they have the authorization for you to call them? Voicemail, pickup, or not? I don't have to pick up for you to violate the do not call list. You can't call me if I'm on the do not call list. So
that's a really interesting point because we get that question a lot. Like I've always said, if you leave voicemails, it takes away the time and your dials, and it makes so you can't dial as many numbers. But what you just said means that I could run the liability of really telling them really well who I am and causing them to call me back and use that information against me at a later date. So there might be a FTC, FCC, YMCA reason not to put that voicemail out there.
Yes, young man, there might be some steps that you could have there. I would be mindful of, again, you kind of hit it to me. There's two kind of issues here. There's the legal issues that we've talked about, and then there's the best practices business-wise. But do you want to leave a voicemail? What are the percentages of these people actually calling you back? What are the percentage of these people filing a complaint? I mean, the whole purpose of it is you want to engage. And most importantly, you don't want to offend these people so that down the road, they don't say, let me tell you about this horrible real estate agent who wouldn't stop calling me. I'm going to tell all my friends about this terrible person. You don't want that either. So to me, that's a business decision on how you want to run your business versus a legal issue with liability. Liability is going to be the same if you're calling them at all, voicemail or not. If you leave a voicemail with, hi, my name's Dave with Shady Real Estate, and I don't check the do not call list because the rules don't apply to me. I want to sell your house. That could be a problem. But again, best business practices. So I think that the idea of making the decision on whether or not to leave a voicemail message is a business decision. Because the liability, look, if you called and I don't recognize the number and I'm on the do not call list, I can file a complaint against you.
I think you should always scrub your numbers against do not call lists for sure. But a lot of these rules get put into place because people abuse the system, so to speak, right? And in fact, just sitting here on this, recording this, I just got my third text message, right? This one's from a broker in town. So I really want to talk about how to file complaints. I'm kidding. Okay. I'm kidding. I'm not. It's just a recruiting.
You said I could text you. You gave me permission.
But now I'm mad.
Google do not call list and file complaints. I mean, you can't.
No, I'm not, because I think it's still a good way to do business. I don't think you need to abuse it, right? And you need to have some common courtesies, and there is an opportunity to opt out. So that's good.
To me, it's like when I talk to my kids and say, this is why we don't have nice things. Because people abuse things, and that's why we have these rules. So
I remember, now that you're talking about this and now that we're discussing, I remember when I was the president of the board and you were legal counsel for the association, this crazy guy in Mesquite, and I don't want to say crazy guy, maybe he wasn't crazy, I was just crazy. He was in Mesquite, he had his home expired, and he was getting 20 to 30 calls a day incessantly, and he got so pissed off that he filed a complaint against everybody, including the Board of Realtors, the state of Nevada. He named everybody he could. He was threatening our lives. He was threatening to come down and kill us. I mean, like, this guy went absolutely crazy because his phone kept ringing, and he had a landline, it wasn't even a cell phone, and it just kept ringing. And he said it would ring into the night, and he would tell everyone, stop calling me. Do you remember that, Dave? I mean, like, the guy just went nuts about it.
Unfortunately, it wasn't an isolated case. That guy took it to more of an extreme, but this was a regular occurrence for me to get phone calls from the public complaining about this. And it put me in the awkward situation of saying, we can't do anything about them. They're independent contractors. But if they're bothering you, you have legal rights. You could contact the FCC. And so the key there is, and I feel bad for folks who have expired because they do get blasted by that. So I see that there's a couple of problems there. I see a failure of the listing agent to communicate with, hey, we're going to be expired. We're going to come up. This is most likely going to happen. If you don't want it to occur, then let's talk about ways to, you could put your number on the do not call list, things like that, because this is going to happen. Second of all is the hours. Like, you've got to really be on top of when those calls and texts are going out. And gosh, I'm sorry, I sent you a text at 3:00 in the morning is not a valid defense if somebody filed a complaint. You don't have an excuse. So making sure that your business, and then making sure that if the company that sends those makes those mistakes, again, looking at your agreement and making sure they're going to protect you rather than letting you just be left there holding the bag. Those are all questions that you need to ask to your vendor. And you're right, this stuff happens. And the problem becomes there are, bad actors in real estate who call this guy 20 times a day. Sorry. That's the reality. The threats to everyone else were, and to me, that's just a sign of consumer frustration. He couldn't get these people to stop contacting him, so he went to the real estate board, and then he went to the realtors, then he went to the state because they won't stop calling. So again, people would just acknowledge that and put them on their do not call list. I don't think there are, hundreds and hundreds of thousands of agents in the valley that are calling expireds. Maybe there are,
No.
but to me, it's a handful of people that are doing this, and they're incredibly aggressive, which is fine. It's legal to do this, but they have to be mindful of this person's rights, and they'll file complaints. The problem becomes, since we talked about like where's the exposure and liability for the broker, this would be a scenario where there would be exposure and liability to the broker. Can you, I know that Dave is texting people at 3:00 in the morning saying, I can sell your house. I need to go in and tell them, hey, we're getting complaints. You need to stop. And that would be enough to protect the broker from the FCC and the real estate division and everything else. Now, trade organizations, the realtor association is kind of like a union, where we really don't have the authority to do anything. If you'll remember, what we usually did was we sent out a blast message to everybody, just a reminder.
Don't do that.
Anytime you saw an email blast, like saying, just as a reminder, like at least when I was there, just as a reminder, the do not call list applies. It meant that we got lots and lots of complaints, and so we were doing something to show we were being proactive.
So there's still rules. These ones didn't get enforced at this point. But moving forward, I mean, what are some good practices and things that we should be doing? Because whether this ever does in this kind of the way it's written now, I foresee in the future there will be more regulations that come down, because I don't think anyone's going to back off. It's an easy way to mass contact a lot of people, and they're getting results from it. Otherwise, they wouldn't be doing it, right?
Yeah. So there are other provisions of the TCPA that are going to go into effect in April of this year, including the consent revocation provisions. So businesses still need to monitor what the FCC is saying and adjust. It's the 101 rule has been found to be unenforceable, but there are a bunch of other things that are coming into effect in the next 3 or 4 months that agents need to be mindful of. So what I would tell the takeaways for the agents right now are, take a look at your process, how you're doing these types of calls. Make sure that your vendors' contracts are protected and that they have obligations clearly set out on what they're going to do in these types of situations. Check and see that your business is in compliance with FCC rules. I mean, that's your obligation as an independent contractor or as a team. It's your job to go out there and check into this. I'm only a 2-man team or I'm a small real estate brokerage in Nevada isn't an excuse. You're going to have to know these things. If you're a brokerage, reminding your agents to be mindful of these things is pretty much, what you guys are doing here with this podcast is a good example of like saying, hey, you guys have to be mindful of this. But they're independent contractors. They're at the end of the day, each individual agent is responsible for this. The size of the business is not really relevant in this negotiation. So what I would say is be mindful, check your rules, sit down with if you're a team, sit down and look at your team agreement, check your provider, and come up with some best practices for compliance with these things. And frankly, you can have an attorney do it. That's always a good idea. But at least a basic first step would be to, go and do a quick internet search for best practices on these things. I don't know. There might be even some continuing education on this. Maybe I don't know. You would think that there would be, but at least getting some best practices and talking to somebody and reviewing the agreements you have.
Okay, and so. Yeah, that might be a good CE class for you to write, Dave.
I just wrote it right now. I'm just here taking notes. Hey, Dave, I got to ask you a question that's kind of interesting on this whole last couple of years. Like, I'm just thinking back, I know that some of these guidelines have been in place, but they've gotten stronger. But I noticed that over the last 2 election cycles, politicians on both sides of the aisle have used robocalls and auto dialers and voice, slide dial voice messages. It was massive in the last election. I mean, I feel like both candidates are good friends because I got so many voice messages from them. Do you think that had a lot to do with this not going forward because now they're using it for their campaigns?
Election rules are completely different than business rules for phone calls. They're completely separate and they're completely protected by 2 different government organizations. So not to say that politicians have created their own rules, but the election stuff is a little different. It's not the same analysis.
I'd call a complaint, but they probably report me.
My understanding was that on the do not call, the exemption was election calls and survey calls.
The election stuff is pretty common to be excluded because they feel that there's a national interest in having politicians communicate with their constituents. There are requirements and obligations for them about setting up these types of things, and we do see lawsuits against people that are getting this. You see it a lot in Nevada with gathering signatures for voter decisions and on election days and those kinds of ballot questions. You'll see that. You'll see a lot of questions about collecting absentee ballots and things like that. So there is a lot out there. But again, part of the problem with technology is technology moves really, really fast. And the law is designed to move very, very slow because we don't want knee-jerk reactions. So sometimes it takes, to me, this is an example of technology really evolving with the abilities to send messages and communicate. And the law, a law from 2012, how does it foresee the future with technology we have today?
all I ever really hear from these types of conversations is that if I can show in a court or in a commission hearing or something that I have a policy in place that says I abide by these correct guidelines, here it is in writing, and here I've had it since this period of time, and I tell everyone I work with that I'm going to abide by it, and here's what I do when I get these calls. Usually you're more defendable when you have something like that versus somebody says, what? I don't know what that acronym means.
And if you have a policy, you had better follow it. Just writing it down and then not doing it is actually, in some ways, maybe even worse. So if you've got a team and they're doing this, and you're doing, Team Awesome, because I legally changed my last name to Awesome, so I can do that in Nevada. So I'm Team Awesome, and I've got 5 members, and they're all calling, and 2 of them aren't following these rules. Guess what? The entire team is liable. So you need to have that conversation with everyone who's involved with your telemarketing. And this should be something you review on a regular, probably annual basis, when you're going through and making sure that you're still in compliance with all these things. Unfortunately, federal laws aren't like in Nevada where, they go into effect within a certain period of time. These kind of just pop up, but there's a long period of time. Like this law that's going into effect into April of 2025, with these changes, it's passed in 2023. So there's lots and lots of time, to come into compliance with this. So it's not like it was a surprise, but you need to be mindful. And since this is a legislative year in Nevada, there'll be some changes in law in July, and there'll be some changes in October. So you'll need to be mindful of those as well.
Good deal. Any last questions, Chris?
No, I can't recall any right now because I'm afraid.
So you're clear?
Turned in.
You're clear?
He's checking to see if he got consent to ask me questions before,
right?
Before he asked.
No, I did.
You opted in, Dave.
I do have one last question, Dave, and it comes to text messages because this was a big part of that about the consent and the conversation. I've seen a lot of agents just because of the personal feeling about it. Like it seems easier to text somebody than it is to make a hard phone call to call them. And surrounding that process, like I just get a number of somebody randomly and I send them a text. If I don't have that opt-in or anything like that, they technically could report me. Is that what I'm taking away from this? Or I need to be very mindful of it?
You're going to love my answer. It depends. How you got that message is important. Like, for example, if I give you my phone number and say, hey, I'm interested in buying a house, I think you've got legitimately enough to initially contact. If there's somebody that you've already had an agreement or a relationship with, reaching out to them is okay. Where it gets tricky is if you just kind of randomly find a phone number and start texting. The surrounding is going to be key. I mean, how you got the number. Like if a friend of yours comes up and says, hey, my friend Jim wants to buy a house, you could reach out and say, your friend Jim gave me your number. Now, if that person says, don't call me anymore, you need to take them off your list. But initially, it's just about, doing your due diligence and having having a process in place. So, if you're just randomly, finding phone numbers, and just text them out of the blue, I think you're going to have a problem. But most agents, when they have that kind of situation that you're describing, there's going to be some sort of introduction. Hey, I got your number, at the Little League, or hey, I got your number from, our work at a charity or whatever. So there's going to be an introduction. And then, once they tell you, don't contact me, or I'm on the do not call list, then you need to agree and back away.
So I just want to put this out for perspective, and I want Brandon to answer the same question. I got my license at the end of 2004. Do not call registry went in 2003, I think, somewhere in there. Maybe it was 2002. I don't know, somewhere in there. 1991, this Telephone Act went in. That was way before I even had a phone. Over the course of my 20 years in the business, I can count on one hand the amount of people that have ever, when I called up and said, hey, I'm a realtor looking to help you buy or sell or whatever, or text or anything, maybe 2 or 3 have ever said, hey, don't call me again, or hey, I'm on the do not call list. That's all I can think of where I've ever seen that. Now, of course, the situation at the board where, random people are compiling against somebody. But for me as a practitioner individually in my own business, it's not a major occurrence. And so I want to be very, very mindful of it, but I don't really see it happening that often. Brandon, how many times do you think it's ever happened to you?
So my experience is most of these things happen because you're dealing with somebody that's rude on the phone. And when I say rude on the phone, it's the agent that's calling, right? They're not respectful of the person and stuff like that. Creates an antagonistic thing. That's when you're going to get the complaints. You know, if you've got 20 people calling you in the day and even one or two of them are disrespectful, I think you're going to be a lot more mad that everyone else is calling as well. So I think a lot of it is if you do call somebody, they are on the do not call list, they say I'm on the do not call list, or put me on your do not call list, apologize and let them know you're going to do it, and then do it.
Yep.
So professionally, I've seen a lot of these complaints, but that's just part of my job. Personally, the only time I ever file a complaint, and I have, is when people aren't mindful of what time it is. Like if you're calling me at 5 o'clock in the morning or you're texting me at 3 in the morning, I'm going to file a complaint because you should know better. That's not a recent rule. And you woke me up and I'm cranky. So that to me is the only time I've ever done it. Personally, just don't call me again is enough, or hit their type stop or whatever is enough to do all that. Professionally, but people would contact me when I was at the Realtor Association as their lawyer to complain about stuff like this. So I probably have a warped sense of what's really going on.
So when you say time, is the time that you call, is that dictated based on your time zone or the time zone of the area code that you're calling?
The time zone of the area code. So like if somebody calls me, a 702 number, I think they have a reasonable expectation that I'm going to be in the Pacific time zone. I'm talking about people who are on the East Coast who are calling me at like 5 or 6 o'clock in the morning because they can get those calls out there within that time. And it's an auto dialer. And so they start up at 8 o'clock in the morning Eastern, and they don't have it properly vetted, and I'm getting phone calls that early in the morning.
So it's based on the number you're calling, not where you're at. So be mindful of that as well, right? Okay. Any other last takeaways you think anyone should know, Dave, besides we're monitoring this and we'll make sure that we keep everyone up to date as it comes?
Again, good opportunity. I'll take a big sigh of relief that this rule didn't go into effect, but you're not out of harm's way. So make sure that if you're doing this, it's a good time to do a self-check and an inventory of your processes and procedures so that you've got all those things cleared away.
Perfect. Thank you. Thank you for your time, Dave. We really appreciate you and appreciate all the knowledge you've shared with us over the years. You're still one of my favorite people that to break down things like this for sure.
Well, I've enjoyed it, and let's do it again soon.
Okay, sounds good.
We'll call you.
Yeah, we'll call you.
Call me at 5 in the morning.
Yeah, that he just consented. Thanks for tuning in today.
Brandon, paying attention. All right,
dang it.
Guys.
All right. Thanks for tuning in today's episode. If you found this information helpful, be sure to subscribe and share it with your colleagues. Thanks again, everyone.